Thank you very much, Lindsay. So in light of the pressures on companies and their directors caused by COVID-19, the UK government revealed proposed changes to insolvency law on the 20th of March to give businesses more time and space to navigate these challenging times to deal with the major concern facing company directors. These reforms were light on detail, but it is expected that they will closely follow previous reforms which were published by the government nearly 2 years ago now, but which have yet to make their way to legislation. Please note that the time frame for the implementation of these new changes by the Northern Irish Government is not yet clear. So the first proposed reform of note relates to wrongful trading. So as previously touched on by Lindsay, pursuant to Article 178 of the Insolvency Northern Ireland Order 1989, liquidators of an insolvent company may ask for an order from the courts, making a director personally liable to contribute to the company in circumstances where they have failed to take every step that a reasonably diligent person would take to minimise the potential losses of creditors once they have concluded or should have concluded that there is no reasonable prospect of the company avoiding an insolvent liquidation. The proposed temporary suspension to the current wrongful trading provisions will run for a 3-month period, which may be extended. This suspension is to be applied retrospectively from the 1st of March. So this suspension practically will give company directors greater confidence to use their best endeavours to trade during COVID-19 without the threat of personal liability should their company fall into insolvency. These changes will allow companies to seek further funding, to continue to pay staff, to continue to pay suppliers when they previously might not have done so. The current laws, which are still in force relating to fraudulent trading and directors' duties previously covered by Lindsay, will stay in force, and these will discourage director misconduct. So it is vital that directors remain fully aware of their wider duties. The next reform of note is the proposed moratorium for companies, which will give them breathing space from creditors who are trying to enforce their debts for a limited period of time whilst they seek a rescue or restructure. This time period is proposed to be 28 days, but this will be capable of further extension by 28 days if certain qualifying conditions continue to be met. I think it's been mooted that a further extension beyond 56 days shall be possible, but this may require 50% in value of both secured and unsecured creditor approval. For a company to benefit from the moratorium, they would need to be financially distressed but viable, and the practical steps for triggering the moratorium would be to go to court to make a specific court filing. One further key factor for any business seeking to continue to trade throughout COVID-19 will be the ability to ensure continuity of supplies. The latest proposed reforms will address this by, save in exceptional circumstances, preventing suppliers from invoking contractual termination rights in supply contracts because a business is subject to one of a specific formal insolvency process or the proposed new moratorium. This change will ensure businesses can maintain continued supply of goods, raw materials to enable continued trading, providing the business complies with the other contractual terms of these supply contracts. Finally, the government have proposed some changes to a new restructuring plan, which was first mooted in 2018. This new restructuring tool will share similarities with the current scheme of arrangement, which can be sort of currently available pursuant to the Companies Act 2006. This is a debt compromise plan which would be agreed between a company, their creditors, and which a company could use to bind classes of creditors which do not vote in favour. So any business who is in financial difficulty should seek appropriate professional advice to consider this new restructuring plan alongside other current processes such as CVA or administration.
Okay, thanks, Colin. We're now going to move on and look at COVID-19 and contract management. You may have heard much commentary around the term force majeure in the market, and there's much confusion around this expression. To be clear, the term doesn't refer to a legal doctrine that applies as a matter of law. Instead, the expression force majeure is used to describe a contractual term in a contract which provides that on the happening of a specified event or an event beyond the parties' control, then one or potentially both of the parties may cancel the contract, or it could be that it's cancelled automatically, is excused from performance of the contract in whole or in part, or is entitled to suspend performance or to claim an extension of time for performance. Whether or not a force majeure clause will assist in suspending performance obligations under a contract, or indeed does give rise to a right to terminate a contract, will depend on the particular drafting of the clause in question, and the general principles of contractual interpretation should also be applied in this regard. It's critical to check your contract to see whether it contains any force majeure provisions or provisions with a similar effect. It may be that they're not called force majeure in the contract, but we'll get used to the same endpoint. It shouldn't be assumed that a force majeure provision will necessarily be triggered by the impact of coronavirus, and this is what's causing a lot of confusion at present. Whether it will trigger that clause depends entirely on the wording of the relevant provisions within your contract and the impact of coronavirus on performance. So for example, is force majeure a defined term? Does the contract include any examples or further explanation of what would be considered to be a force majeure event? If you can rely on such a clause within your contract, then the possible consequences include an extension of time to comply with contractual obligations, compensation for additional costs, suspension of performance, a duty to renegotiate performance, or indeed termination, which could be helpful in the current circumstances. And we would also advise that now is probably a good time for you to review your existing standard terms of business and contracts to ensure that they are sufficiently robust and deal with these types of events as far as possible. So there are some well-drafted contracts that already refer to pandemics or epidemics within the definition of force majeure, and those companies who have had those well-drafted clauses within their terms of supply are finding that they are able to rely on those provisions in the current COVID-19 crisis. So again, it's worthwhile having a look at your contracts to see do they need to be updated going forward. There are, of course, some other contractual implications in the current circumstances and other legal concepts that may assist businesses in managing contract losses or other contract issues during the pandemic, and I'll touch on just a few of those. The other doctrine that you may have heard a lot about recently is the doctrine of frustration. It's receiving a lot of attention as well, and essentially it provides that if it has become impossible to fulfill the contract, then under the doctrine of frustration, the parties are automatically released from their obligations and the contract discharged. However, I would caution you to note that this is a very high threshold. Performance must be rendered impossible, not simply more difficult or more expensive. And again, that is where a lot of the confusion is arising. Unlike force majeure, which arises under the terms of the contract in question that we've just heard about, frustration is a legal concept or doctrine, and therefore, if it is available, it's available as a matter of law. So it's not something that you need to have had written into your contracts. But as I said, it has a very high threshold to meet. Secondly, there may be other relevant contractual provisions within your contract, such as an alternative to force majeure. The contract may expressly provide that the exercise of a statutory power by a government and/or a change in law entitles the contractor to certain relief, such as additional time and/or a termination. You should check whether your contract requires you to give early or advance warning of anything that might impact on your performance under the contract, and further information or updates may need to be provided on an ongoing basis. So that is something that directors should be checking for. You'll also need to look to see if there's any express provisions in relation to mitigation. We've also been asked a lot of questions by our own clients in the current circumstances in terms of contracts that they haven't yet entered into, but they were just about to sign up to. If you are about to enter into a contract, you have to be very careful, because force majeure provisions and the doctrine of frustration are unlikely to be of any assistance to you if any problems emerge, as the impact of the coronavirus is now a foreseeable event. So if you enter into those contracts and later try to claim relief under the provisions because of the impact of coronavirus, it's unlikely that you will be able to do that unless express provisions have been drafted in allowing you to do that. And the reason for that is that you're entering into the contract with notice of this COVID-19 pandemic. Therefore, it's critical to ensure that any contract you're about to enter into contains provisions that will adequately and expressly deal with the impact of the current pandemic, such as suspension, termination, immunity in respect of delay, and potentially variation where necessary. We call those change control provisions, which you might have seen in your contracts, and that sets out the procedure for achieving variations.